everyone. This is the December 8th, 2021 meeting of the Metro Nashville Short-Term Rental Appeals Board. I am the Vice Chair, Terrence Bond, and I'll be presiding over this session. We have quite a big docket today, so we're going to look to move through it as efficiently as possible. For anyone who will be speaking or addressing the board today, you will need to activate your microphone once you approach the bench by pressing the button on the right-hand side that has a person with volume indicators next to it. You'll only need to press it once in order to activate your microphone, and then press it again once you're ready to deactivate your microphone. Should you press it twice, let me know, and I'll have to reactivate everyone's microphones, and then we can proceed from there. If you're addressing the board, you'll have approximately, 5 minutes to speak? Which includes rebuttals?
Yes, unless there's opposition present.
Yeah, okay. So, sounds good. Sounds good. All right, and if I believe that's everything that we need to cover. I should probably listen better whenever I'm sitting in my vice chair seat and not presiding. But I believe that's all the administrative matters we have to cover right now, and I'll turn it over to Mr. Hargis for the rest of the agenda.
Okay. Good afternoon, ladies and gentlemen. The Metropolitan Short-Term Rental Board is now in session for its regularly scheduled meeting on December 8th. I'm Joey Hargis, Metro Zoning Administrator, and I'll be handling the sort of master of ceremonies for announcing cases as such. With me, behind me is our new short-term rental chief, Mr. Mac McBroom. And Mac will be presenting the cases in front of the board today. After we get done with our presentation, the appellants will come first to the table. As Chair Bond said, push the microphone button, identify yourself, and make your presentation. I'll call for, as we call each case, I'll ask if there's any parties here opposed to the case, and if there are, if you'll raise your hands when we call that case. In cases with opposition, each side of the case will have 10 minutes to present their case to the board. The appellant will want to save some of their 10 minutes for rebuttal, but that time is not per speaker, it's per side of the case. So if there are multiple speakers, please divide your time before coming up in front of the board and presenting your case. This board is empowered to act on the cases before us by the Metro Code of Law. Again, we have 5 members present today. You will need 4 affirmative votes to grant your application today. So if we have a vote situation where it's 3-4, 2 against, or 2-4, 3 against, that case will stay on our agenda for the next 30 days. The members who participated are allowed to change their vote. The members who are not present can watch today's testimony and become eligible at the next hearing, should they wish to. If after 30 days you still don't have 4 affirmative votes, your case is deemed denied by operation of law. We'll go through all cases set for public hearing today, and after each case, the board will discuss in front of you and then vote on the cases here. That's it for you. Agendas are just over the table. If you didn't pick one up, feel free. We'll go through all the cases here in the order. Mr. Chairman, I don't have any preliminary announcements. We do have one matter on our agenda, was amendment of your rules, which we can take at the end if you'd like. And that way we can go ahead and proceed with the cases before us today. All right. With that, I'll turn over to Mac, and he'll begin our first case, is case 2021-27.
Good afternoon, board, members of the public. This is case 2021-027, 1018 Kirkwood Avenue, Ryan Clinton and Chelsea Clinton. This is for advertising and operating a short-term rental property prior to obtaining a permit. This is governed by Bill 2019-6. Now, the board does not have discretion to lessen the 1-year prohibition for applying for an STRP permit. In the case of this decision for the board is whether or not the zoning administrator erred in canceling the permit based on the evidence that the property was advertised and operated as an STRP prior to obtaining a permit. On July 8, 2021, application for an owner-occupied permit was filed by the appellants. On July the 8th, 2021, application was being processed by zoning examiner Robert Osborne, who found that Host Tracking, which is the compliance contractor for Metro, for the property recorded 4 website advertisements that had been posted prior to making the application. Mr. Osborne asked Inspector John Phelps to check for other advertisements. Inspector Phelps found an advertisement for the property on the website bookabove.com, which contained the following reviews. Beautiful stay, June 2021 MSC. Overall, we were obsessed with this home. It was a perfect fit for us. It's nicely decorated and clean. Above made sure that we had everything we needed and even brought us groceries. We had a chef one night, too. The beds were comfortable, and I love the luxury soaps. Great stay overall. Perfect, June 2021, Shonda T. Overall, the house is gorgeous and in a great location. It felt spacious and airy. The open concept was great for a larger group. The pool was relaxing, and we used the hot tub at night. We grilled, but also went out for some fun in Nashville. Had a blast all weekend. Number 3, phenomenal stay, May 2021, KDC. Overall, if you're looking for a luxurious place to stay for a large group, this is the place. Our family is a group of 12, and we all felt very comfortable. The location was perfect for our group, too. We enjoyed the pool, hot tub, grilling, and spacious kitchen. The kids liked the game room area. It was just what we needed, and above went the extra mile to make sure we were comfortable. The bottled waters and luxurious soap and conditioner were a nice touch. This information was gathered by Inspector Phelps on the enforcement team and forwarded to the permit issuing team on July 21st of 2021. This was the day the permit was being finalized and issued. This information was not yet included in the application package and therefore not reviewed prior to the permit being issued. The 4 other ads posted prior to applying for the permit as tracked by Gronicus Host Compliance are Home Away, Flip Key, Airbnb, and Red Awning. After the permit application was made, a Booking.com ad was posted on 7/19/2021. In the appeal package on the Metropolitan Short-Term Rental Appeals Board profile page, the reason the appeal for the appeal is the following, and I quote, "Appellant was operating a not owner-occupied STR while having a temporary permit. The appellant followed all the steps to correctly obtain a not owner-occupied STRP, and after having the fire marshal inspect the property, was issued a temporary permit. The appellant was under the mistaken belief that the temporary permit for the not owner-occupied STRP began operating the STRP. See also the appellant petition filed in conjunction with this application," close quote. 2 clarifications regarding these statements are the application was made for an owner-occupied permit, as only owner-occupied permits are available in the R6 zone district. There are no temporary STRP permits. The final petition contains the following, page 5. Further, the appellant acknowledges that there were 3 reviews on the property profile left by above employees and not actual third-party occupants who booked and occupied the property under permit. Stated differently, it is important to note that the 3 reviews that were misconstrued by Metro as STR guests were instead made by Above's internal team to help optimize the website. Page 7, and I'll quote, "It is undisputed that the appellant's property rental management company Above listed the property on its internal website prior to receipt of the permit for the website optimization. However, the appellant nor Above had any express intent to advertise the property for active bookings from the public, and it is unequivocal that that did not have any documented stays at the property as an STR prior to receiving the permit or any time after August 15th as outlined in the notice of cancellation from Mr. Hargis. The 1 May 2021 and 2 June 2021 reviews on the above website ad are the reason the permit was canceled, and in fact would not have been issued had the evidence been reviewed during the application process. Reviews have always been evidence of documented stays without exception. If you refer to the comments in the reviews, it tends to undermine any contention of visits versus stays. An example, beautiful stay, June 2021 MSC. Above made sure that we had plenty of everything we needed and even brought us groceries. We had a chef one night, and the beds were comfortable, lovely, luxurious soaps, great stay overall. Perfect, June 2021, John T. We had a blast all weekend. Phenomenal stay, May 2021, KDC. One further point, the 6 website advertisements for the property advertised 7 bedrooms. The Metro Nashville STRP ordinance has 4 bedrooms as the maximum. There were no documented stays after the August 15th, 2021 date as prescribed in the cancellation letter. And there were no documented complaints for the property in either the Metro Hub nor with host compliance.
All right, I believe is that the city's presentation? Okay.
Do we ask questions of staff now or after?
I think once we open the public hearing, we can direct questions either to the appellant or. Okay. Okay, perfect. Then we'll open the floor for questions to the city.
Okay, great. Can I?
Go ahead.
Thank you, Chair. So that was a lot of background information. I heard some talk of the appellant believed at one point that they had a temporary permit, but there is no such thing as a temporary permit. Is that correct?
Yes, sir, that's correct.
Okay, thank you. And in terms of the code does prohibit advertising of a property without an active permit, is that correct?
Yes, sir, that too is correct.
Thank you. So, because I understand that there's some question of whether the reviews were reflective of actual stays or whether what's my understanding is that they're saying, the appellant is saying that these reviews were, I don't want to use the word fraudulent, but they were automatically generated or procedurally as part of the listing company. That's what I'm hearing, is that the listing company made these reviews.
It is the city's position, and I will not speak for the appellant. He may answer as he will, but it is the city's position that what the appellant is putting forth is that these reviews were placed by the advertisement company, management company that he employed to manage and operate and the property as well as the advertisements. The city's contention is that the zoning administrator did not err by the cancellation of this permit based upon the evidence which has, throughout the history of the STRP ordinance, the reviews have been the documented evidence of documented stays. We don't vary from that, and so therefore, based upon the information provided by the inspector in his investigation, the administrator did not err that this was documented stays from our view and from the view of the ordinance. Therefore, the permit was canceled on that basis.
So the permit was not canceled on the basis of the property being advertised without a permit?
Generally, if we do not have documented stays, we will not take it to that degree of cancellation. The ordinance, the strict reading of the ordinance is you're prohibited from advertising or operating without having a short-term rental permit. However, we generally will not do a cancellation on just strictly an advertisement without operation. That's more of an administrative feature as opposed to a strict reading of the ordinance. But there have been extenuating circumstances in numerous cases in which advertisements were innocently placed without intention of any operation. And based upon that, we have to be fair all across the board. We can't do for one and not all. So therefore, that's the general rule under which we operate administratively.
Understood. Thank you.
Any other questions for the city? All right. If there are none, then we'll allow the appellants to be heard.
May I ask a quick question?
Oh, yeah, go
Sorry
ahead.
about that.
I'm sorry.
I wanted to clarify, so this is zoned R8, this property, and at least that's what it's, yeah, and they originally applied for an owner-occupied permit? Is that,
Yes, that's correct, and I believe I misspoke. I believe I said that it was an R6 in the explanation of the fact that there are no not owner-occupied permits available in this zone district. It is R8, and for full clarity, there are no not owner-occupied permits available in R8 zoning district.
thank you.
Okay, if that's all the questions from the board for the city, then we'll go ahead and hear from the appellant, or the appellant's representative in this case. Could you please identify yourself to the board?
Yes, Vice Chairman, or excuse me, yes, Vice Chairman. Seth Klein, Collins Legal, 1811 Fatherland Street, Nashville, Tennessee, 37206. I want to start off, apologize, I'm a little raspy. The fluctuation in temperature here in the Great Mid-State has caused my head to be a sinus issue.
You are not alone, Mr. Klein. I'm suffering from the same myself, so we can trade coughs.
That's well, I'll try to minimize that, and hence the water bottle.
Before you launch into your presentation, where are we keeping the time? Okay, that'd be great.
5 minutes,
No opposition present.
And for clarification, would Metro be considered to be in opposition to this, given that they are an entity to this, or is that just strictly public opposition?
Well, it's a city's case, so it'd be public opposition.
Understand. Thank you. And I'll reserve 1 minute for rebuttal.
Okay, go right ahead.
So as Mr. McBroom highlighted, but I don't disagree with most of those facts that were stated. The crux of this issue is, which makes it slightly unique, and to answer your question, Councilman Member Parker, the difference in whether there's a temporary permit or a permit issued, if you look in page 2 and 3 of my brief, in certain situations, there is a temporary number issued, and that's a T 2021 or whatever the permit number might be. That on that specific documentation that is sent out, it says specifically, this is not a permit. Whereas the information that my clients received on behalf of the applicant, they actually received their permit, and it did not indicate that this is not a permit. It was a screenshot that's attached on page 2 that said the permit expires 1 year from date. To address some of the key points, yes, this property was advertised on the property management's internal website, Above. Above is a national property management company that has a headquarters in Dallas, Texas. They have a branch here in Nashville that manages their Nashville properties or within Middle Tennessee. The issue in this case, what happened was when the permit and all the documentation was input into the system here at the local branch, the national or the corporate office or headquarters, they errantly took that to believe that the permit was valid, and so they listed it on their website. Those reviews that were left, that was for SEO, search engine optimization, and that's also for their internal website to get these properties to start showing up on searches and filters whenever people are requesting or trying to book through Above specifically. So as a result of that, and in the mix of the corporate company trying to speak with the local property management company, there was some confusion in that. So again, I will not try to pull the wool over your eyes and say that it was not advertised, and that is what the law says. However, again, what we're trying to accomplish today is a reduction of the 1 year injunction to a 6-month injunction. And the purpose or the why behind that, and what I really think, again, makes this slightly a unique situation. There were no stays before the permit was issued. The only documented stay was August 13th through the 15th, which again, as Mr. McBroom indicated, was within the 15-day window pursuant to the notice of cancellation. They, above at that time, ceased all advertising. They made multiple instances to reach out to Mr. Hargis, Mr. Vrabin, and Metro to try and rectify this situation and to try and do whatever they could to resolve and remediate this notice of cancellation that they received. After about a month of inquiry with multiple individuals, including their council member, that they received a response from Mr. Vrabit saying that the property was operated prior to the issuance of a permit. However, again, it was not operated as, it was advertised as. And I know that that is a fine classification of words or distinction of words, and it could reasonably be argued that operation is the advertisement and or use of the property. So again, I understand that that is a contestable point in this case, but in my opinion would be the only contested point, given that they're not bad actors, there were no prior. They went through the process to try and obtain this permit, and that simply there was just a administrative issue on the property management company's side. Hence, the property management company's desire to seek to try and rectify and remedy this situation. In short, again, it's not contested that this property was prematurely advertised. However, they went through the process to get the permit. They would have otherwise been approved for the permit. There were no documented stays. As soon as they received word from Metro, they immediately ceased all operations. So in short, we're asking that just pursuant to section 6.28.030A51, this is treated as a situation where a short-term rental property is operated without having renewed a previously issued permit, and that there would be a waiting period of 6 months rather than 1 year. Given the limited amount of time, I hope that you review the brief and see that point there. But if I have any questions, I'd be more than happy to answer any at this time.
Sure.
Thank you.
I have a couple of questions, Mr. Klein. I guess one of the things that sticks out to me is your contention that there were no stays and that these were employees acting under the direction of their employer above to go and comment on the property and visit as opposed to stay. Do we have any proof in the file or with you that these were in fact employees and that they were acting under instructions from their employer?
So, Vice Chairman, I believe it is Exhibit 6. Okay. What I included in that is an owner statement of the bookings, and to show that where it's a P&L sheet from January 1st through August 31st. Yes. And so that would show on there when bookings took place, for instance, the 8/14. All transactions or any sort of commissions or expenses that were associated with this. Mm-hmm. And in my opinion, based on this P&L sheet from the period of 1/1/21 through 8/31/21, it would show that there were no documented stays. There was no money that was exchanged or anything of the sort outside of the 8/13 to 8/15, which is listed at on that first line item, booking 01590.
I do see that, and thank you for pointing that out. I don't see that this is an attested or notarized statement. Is there some reason that the statement wasn't attested or notarized as to the truth of the contents?
No, sir. And to my knowledge, I was unaware that petitions need to be attested to.
It's not a requirement. However, it would just tend to support the veracity of the claims being made therein, especially if there are no statements from employees or the employer.
I have R.J. Rowan, who is the property manager and for above here in Nashville. Okay. So I would, Vice Chairman, if you would allow him to speak to that, I think that that would, I don't know if we can swear him in or not, but but if that would work for you, that would be my response.
Happy to hear from him.
So just state your name and your address and then answer the question.
My name is R.J. Rowan, 7113 Charlotte Pike, Unit 558, Nashville, Tennessee, 37209.
Okay, thank you, Mr. Rowan, for joining us.
Of course.
So do you have with you any proof that that these employees who visited the property were acting under your instruction solely for the purpose of search engine optimization or some other purpose not related to an actual stay?
Yes, sir. So it's a common practice for all of our properties just on our internal website of Book Above. Mm-hmm. If you were to audit, say, VRBO or Airbnb, our those reviews can only be posted on our site, so there were no reviews on VRBO, Airbnb, anything like that, because that's a third party, so.
But those reviews are accessible to the public since we have a copy of them right now, right?
Just on our website, yes, sir.
Okay. So if in fact that is true, the statements that they made, which actually go into greater detail than just it's a beautiful place, it's a beautiful property, would actually be misleading to the public if they're true.
Absolutely.
Okay.
Absolutely. And so I think the purpose behind that is to try and give potential clients a sense of the property that they cannot pick up through the description or through the pictures.
Okay.
And also highlight the services that we provide.
Okay, thank you. I have one more question for Mr. Klein, and then I'll let the rest of the board ask whatever questions they may have. Mr. Klein, when you started your presentation, you said that the relief you're seeking is a reduction of the waiting period, which, as you heard in the city's presentation, is not something that we have legal authority to do. So, in saying that that's the relief you're seeking, are you conceding the fact that the zoning administrator did not err in making the decision to cancel the permit?
So in the alternative to not conceding that the zoning examiner did not err, in what I would say that our position would be, our alternative request would be that we would concede that the zoning examiner did not err, and that we would request in that instance, based on the facts at hand, that the board reduce this from a 1-year injunction to a 6-month injunction based on that's going to give me 1 second, Vice Chairman.
Sure.
I apologize.
Sure.
So in my brief on page 6, going to page 7, however, when an STR permit is denied based on the determination by the zoning administrator, the penalty is significantly shorter as outlined in MCL 628.030A.5.1.6.2. Also note that the section of the Metro Code delineates that the penalty for failing to renew an STR permit as compared to operating without having obtained a permit is also subject to an even shorter enjoyment period than someone operating without a permit. So in this case, based on the very unique facts of the circumstance, it is my position that I would request the board look at this and through that lens, that this is a situation where a permit was obtained. However, given the administrative errors that the property management company made in the advertisement of that property internally, that this would be more considered to be a situation where they had operated a permit, and rather than failing to renew, they, again, steps happened in there. So that would be the exchange or the difference in the comparison. But that this would just be a situation where would be more suited for a 6-month injunction than a 1-year injunction. Again, given that they did obtain, qualify, and approve for said permit.
Okay, so my brain's retention capacity is very small, especially in these COVID times. So I want to just confirm that I understand you're saying you do not contest the proposition that the administrator did not err in canceling the permit.
I do not contest that.
Okay.
Yes.
Perfect. That is all my questions.
Mr. Klein, I have a question for you. Metro's provided information that there were ads posted even before a permit was applied for. I have the application date as July 8th, 2021, and it looks like the advertisement URLs that we were provided show listings on HomeAway, Flipkey, Airbnb, and Red Awning prior to the application even being filed. Can you provide some clarification as to that?
Board Member Kimberly, one of the downfalls I've found with the STR board so far is that we're not provided with that information similar to the way we would be at the BZA appeal to be able to answer that question. So I haven't seen what you're looking at, and without looking at that document, I think that it would be not wise for me to comment. So if I could see a copy of that information, that would be, I would appreciate that. Board Member Kimberly, so conferred with Mr. Rowan, and you addressed me, so I want to answer your question.
Whoever is best adept to answer this question, or best equipped to answer this question, either one of you, please.
Would you like
let me
to? Go ahead.
Board Member Kimberly, so we use a property management software, and so we had obtained the property prior to receiving the permit, and so which is common practice, is after the home is photographed and everything, we build it within our property management software. And me being at the local office knew not to push it out prior to receiving the permit. That information was not given to our corporate office. So in error, not only did they post it, they also posted the reviews. So that would fall under the same administrative error done by the corporate office and has since been rectified.
Okay, so in the discussion that we've had, though, I'm trying to make sure I understand this. The way that this has been framed is that all of this information was on Above's internal website. These are external links to places where you go and book stays. These aren't internal postings. Can you clarify why these are showing up as external postings when the framing of this the entire time has been, this was just on our internal website?
So we're not contesting the fact that the property was advertised prior to the receiving of the permit. However, on those VRBO, Flip Key, Airbnb, Red Awning, there were no reviews because there were no stays. It was only our internal website where we have the authority, for lack of a better term, to post reviews. We can't go, our employees can't go and post reviews on VRBO, Airbnb, anything, because there was no monies transacted, there was no documented stays, and so therefore we're unable to post any reviews on those websites. So the only place where there were reviews posted was our internal website.
Okay, so the reviews were on your internal website.
Yes, ma'am.
But the ad postings were on external websites as well.
Correct.
Okay, that's what I was trying to point out
And
to.
Board Member Kimberly, I want to, in full candor with you, this is the first time that I've seen this information and or knew about this information. So by no means was I'm trying to mislead the board in stating that. I understand your question and where you're going with that. So I do want to be very, very clear and transparent with that.
Thank you, Mr. Klein.
Yes,
I just
ma'am.
wanted to make sure
Yes,
I
ma'am.
had a full
I certainly understand.
understanding.
Yes, ma'am.
Okay, no further questions from me at this time.
I have one question. Does the owner live at this address?
Yes, sir.
Okay, so it is an owner-occupied
Yes, sir.
property. Thank you.
Board Member Loico, I think the issue that Mr. McBurn brought up on the application, there were two initial applications. There was another representative for this matter on the initial STRP appeal, and I think that when we were getting those things situated with Ms. Shepard and Ms. Lipsey within Metro, I think that that's the reason why it might have been listed as a not owner-occupied on that application, but it is a owner-occupied permit.
Are there any other questions for the appellant and his counsel? All right, hearing none. Mr. Klein, if you have a rebuttal, I believe you have a little less than 1 minute.
I think that I've taken my time, Vice Chairman. I appreciate it, though. Thank you very much, sir.
Certainly, certainly. Well, in that case, I think we will close the public hearing and begin our deliberations. Okay, so I think where I sit is I don't think we have any discretion here to make any decision other than leaving the 1 year waiting period in place. Mr. Klein said on the record that he concedes the fact that the BZA did not err in making its decision, and that was the only basis that we would have for overturning, or the only basis for decision that we have in this case. So unless the law is wrong, I don't think that there's really much for us to do other than vote to adopt the BZA's decision as ours. The administrators, excuse me. Yes.
Can I ask a question of legal counsel?
Yes, absolutely.
For legal, I was wondering, so there was a rationale hinted at by the appellant for interpreting this as a case where we have discretion to reduce it to a 6-month. Do you have, what is your read on that? If you recall the argument that was made, I believe it was, or the case that was made, I believe it was that that a permit was, I don't want to misquote the person, so I'll see if you recall it.
And before you do that, I'll say that, I'll add that I didn't view the section that was quoted in the brief to be applicable to this set of facts, given the year in which the permit was applied for, but I could be wrong on that. So yeah, please correct my misapprehension.
Yes, and I think the vice chairman is correct. It is based on the year in which the permit, whatever year he received the permit, he's grandfathered into those laws at the time. And I'm not sure if that case was in the year he received the permit. What year did you receive the permit?
It was this year.
2021. So, and when was the case? I'll look it up.
The 2019-6 was passed at the end of 2019.
Okay. And I would just ask for a few minutes to look that over, if
Sure.
that's fine.
I'll just, while I've got my mic on, I'll say, I'm going to have a hard time determining that the zoning administrator erred in this case. And my understanding is that we do not have any authority to reduce the wait period. But I did want to ask for clarification from legal on that, so that's why I did that.
Any other commentary from other board members while we're waiting legal counsel?
I agree. I think we've got to have clarification on from how we can act
Right.
in relation to this, but I don't know that it's worth discussing.
Further, if we don't
Yeah.
truly have any discretion, then the decision is made.
And after speaking with staff, who is a bit well-versed on these bills, I'll be candid, he's indicated what the vice chairman indicated. The discretion of the board is whether or not the zoning administrator erred.
Okay. So, given the advice of counsel, I'm inclined to go with my original recommendation, which is to find that the administrator did not err in canceling the permit, and that the request for relief from the 1 year delay in applying for a permit is denied. I'll entertain a motion to that effect if the board members agree.
I'll move to that effect.
Is there a second? Okay, there's a question on the floor. All in favor, please indicate your assent by saying aye and raising your hand.
Aye.
Okay, the vote appears unanimous. Thank you, Mr. Klein, for your time.
Okay. The next case 2021-28, Ezekiel Akade, the appellant and Primetime Trust, owner of the property at 4303 Gallatin Pike, District 208, is seeking permission to apply for a permit earlier than the law allows. The appellant is operated after the issued short-term rental permit expired. Is the appellant present in this case? Yes, sir. Come on forward. Have a seat there. Mr. McBroom will go through his presentation first, and then we'll turn it over to you, sir.
This is an OR 20-A zone district where not owner-occupieds were available at the time of issuance and are still available at this point. At the time of the issuance of this permit, which was November 25th of 2019, that the bill that was in effect at that time was 2017-608, and that is the bill that governs this permit. The effective date of that bill was 2/2/18. The board does have discretion to reduce the one-year wait period. The wait period is 1 year either for operating without a permit or with an expired permit under this bill. On November 25th of 2019, not owner-occupied STRP permit issued. On December the 8th, the first Airbnb ad was posted. December the 15th of 2019, VRBO ad posted. February the 8th of 2020, the second Airbnb ad was posted. On November the 10th of 2020, the first Airbnb ad was removed. On November 25th of 2020, the permit expired. On September 28th of 2021, the STR appeal was filed. There were 30 document stays after the permit expired, 4 of which occurred after the STR appeal was filed. As of 11/30, the second Airbnb ad remains posted as well as the VRBO ad. Both ads' calendars have a 2-night minimum stay, and I rechecked that this afternoon. Both ads remain posted, but there are no additional stays other than what was previously listed. There was one documented complaint from on the property from the Metro Hub, and there were no documented complaints for the property with the host compliance hotline.
If there are any questions for the city?
Mr. McBroom, what was the complaint in the Metro Hub system for the property?
I received a hub complaint, which is via email, that was routed through the mayor's office. The complaint was not only concerning this particular unit, but I believe that there are 8 units at this particular condominium property. And it was concerning the permit status of each of those units, whether they advertised and operated as a short-term rental property, and if so, if they had the proper permits. Upon the review of that condominium complex, we discovered this permit had expired.
Mr. McBroom, did you say that the property is still presently listed for minimum of 2-night stays?
Yes, sir. 2 of the ads remain posted as of this afternoon.
Thank you.
But they do not have additional stays from the ones previously listed.
Okay. Any other questions for Metro? All right, in that case, Mr. Akande, you may make your presentation. Please identify yourself and state your address. You'll press the, yeah.
Oh, okay. My name is Ezekiel Akande. I live at 342 Shadow Creek Drive, Brentwood, Tennessee.
Okay.
I'm the appellant, and I'm also an officer of Prime Select, LLC, the owner of the property in question at 4303 Galantine Pike, apartment 208, Nashville, Tennessee, 37216. Like I said before, I'm the appellant on behalf of Prime Select, LLC. I'm seeking permission to reapply for the STR permit, earlier denied as a result of non-renewal of the permit number 202-10062284 for short-term renter as at when due. The condo located at 4303 Galantine Pike, Nashville, on which the apartment is domiciled has a zone classification of OR20-A, and it's one of 16 units in the condo. Majority of the units are on short-term rental, and they have legal permits, to my understanding. I received my permit in November 2019. A few months after that, after I had furnished it, just as the cusp of the COVID-19 pandemic, I couldn't list it. It was even February of 2020 that I listed it. And there were no guests for a long period of time. And I couldn't even go to the building because I too was isolated because I was sick. So by November of 2020, I had to travel abroad to bury my mother. So for a whole year plus, I did not get to the apartment. It was until March of this year that we started having tenants, guests once in a while. We never had any. It was a loss. At one time, I had told the estate, the same condo, to rent it long term. They couldn't find any rentals. I wanted to sell it. I couldn't even, there was financial loss here. So it wasn't a very good purchase at all. So when I came back from abroad in February, we started to, look at the ad. Sometimes people will show interest from before, but if there's no response, they just don't come. So I didn't even, for a while, I couldn't manage it. I had to ask someone to help me, but they too wanted too much money that I could pay. So, but by March, April, May, we started having guests. And I went there and I found that the permit had expired. So immediately I called the department here and I brought the form, a completed application here at 800. And they called me a few days later to say that I had to bring a check. And I brought it myself as well. So, but I waited for months until they sent me the application and said the application was denied. I was surprised. I said, okay, what do I have to do now? They said I have to appeal. And apart from that, I wanted the check back. They said they couldn't find it. There was no evidence that I had submitted it. And every time I come, I bring the check myself. And because of COVID-19 and the reduction of contact, they will tell you to put it in a corner, in just a basket. And that was what I did for the form as well as for the check. I came back again to check to see if they have found the check. And I couldn't find it either because the bank that I was using at that time had, for some reason, closed my account. So, and I searched on my end, I couldn't find it, but I was certain that I brought the check and the form. The form was acknowledged nonetheless, but the check was nowhere to be found. Anyway, that's not even the issue. I just want to crave the indulgence of the board to, allow me to have my permit back. If I don't have this permit back, I'm just going to, it's going to be financial disaster. So, and this thing had been closed for a long time, but Airbnb and Verbo even gave me...
Mr. Conde, I do apologize that your time has elapsed.
Oh, really?
So
that was fast.
I hate to cut you off, but everybody's allotted 5 minutes.
Okay.
Unless there are members of the public here that would also like to speak. Okay. In that event, we will open it up to questions from the board members. And actually, I'll start with one. You mentioned that you had returned from being out of the country, and then you went to the unit and saw that the permit was then expired.
Yes.
Can you please say for me again what date that was that you saw that the permit was expired?
I think it was around April or May.
April of 2021?
Of 2021.
Okay. And so, and then you made application for the renewal when?
Geez, I don't remember. I think it's, the initial application was in that May.
It was in May?
May or June, yeah.
Okay.
May or June, if I may. But I did not receive a denial until like around September.
Okay.
Yeah.
Okay.
I thought everything was fine.
Mr. Vice Chairman, just one point of correction of the applicant. The date on his affidavit is listed as August 6th of 21.
Right, I did see that, but I seem to hear from him that there was some confusion as to when he had applied and when a check had been issued, so I wanted to make sure I was clear on those details and what his understanding was as to when he had noticed and then made an effort to comply with the law. But I did note that the affidavit says August the 6th. So you were aware, there's no question, you would not dispute that you were aware that you had lost your right to operate a short-term rental property in April of 2021.
Exactly. I became aware much later. I mean, the COVID-19, my own isolation, everything did me in for a whole year. I lost money. I wasn't at that apartment at all.
Sure.
So I wouldn't know because I had it pasted on the kitchen cupboards.
Right.
So as to at least alert me every time I see it if there's anything I needed to do.
Okay. And so, but it looks like there are a number of documented stays after April 2021 when you discovered that the permit was expired and that you needed to renew it.
Yeah, because I applied, and it was accepted.
Right.
And they even called me for a check. So I thought, it's a matter of just picking up my my permit again.
Okay.
You see, until the form actually was returned to me and crossed over.
Okay, if you thought that your permit was renewed and you were okay, why would you file an application on August the 6th with an affidavit attached saying that you want to be issued a renewed permit?
Yeah, because that was when I received the denied form back.
Mm-hmm.
I think I received it at that time. And they said I have to. Mm-hmm. I don't know the time, but I can.
Right.
I wish I had the timeline right.
Mm-hmm.
But after they talked about appeals,
mm-hmm.
that was when I had to do the appeals.
Do you remember receiving correspondence from Metro on August the 27th of this year saying that your permit was expired and that you needed to actually renew your license?
No.
You don't recall.
I don't.
But you
don't remember.
You did indicate that you received.
But I think I remember receiving in September, not in August.
Well, it was the date of it is August 27th, so it's very likely that it would not have reached you until September.
Yes.
Okay. All right. I believe that's all my questions.
Sir, do you recall or do you have documentation for where you tried to renew the permit in May of 2021?
Do I have?
Do you have any documentation? The way I'm understanding your explanation today is that you came back in the country April or May 2021. You realized the permit was expired. You attempted to renew the permit in May 2021 after you realized it was expired. Is that what you've testified to today?
Well, the timeline is what I cannot really tell you right now. But immediately I found out, I did that. Because at this point, I was responsible for the cleaning of that apartment. I couldn't afford to hire anybody because it hadn't made money for over a year. So that was when I noticed it. There was no way I wouldn't have noticed. I did, so and I applied immediately. I actually called at first. Then they told me what I had to do, and which was to go into the website and print out the forms and fill it out and bring it and notarize it. And I did that. I actually brought the form myself. So,
when did you go into the website and have the notarized form?
Yeah, I think that was immediately around May or June. Okay. That was when I went. I was informed I had to do that. I never knew how to do that previously.
Do you recall having the form notarized more than once, or did you just have a form notarized one time?
I notarized the form in two places. One got missing. Then I did another one in another place. So that was what I remember about that form.
Okay, so you remember having the form notarized one time, and it, according to your testimony, went missing. So then you had another form notarized and submitted the new form.
The first one was I just misplaced it, so I had to do it over again. That was my own fault, so I wasn't
Okay.
going to do it.
So you're not saying that you submitted a notarized form to Metro and they lost it, and then you had to do another one? You're saying you
No,
misplaced
they
it?
didn't lose it. I said I misplaced it.
Okay, all right.
So I had to do another one that I brought myself. I did not send it by mail.
Gotcha.
I brought that form myself. I brought the check myself. you
Okay.
know.
I understand. Thank you, sir.
Yes.
Any other questions from the board members for the appellant?
I guess, yes, sir. So, usually one of the things that we look for is sort of a corrective action on part of an appellant to come into compliance once they're aware that they don't have a permit. So I'm specifically, you filed an appeal on September 28th, and then Metro has at least 4 documented stays since you filed the appeal. And what staff told us is that the ad is still listed at this moment. Can you?
No, they are not listed at this moment. In fact, I have, I've quarreled with Verbal and Airbnb on this. They had to generate letters to me. Unfortunately, I don't have it because I forced them to generate letters to me that everything has been canceled. Because even with cancellation, you still find people. They still put people in. In fact, in November, I had to pay a huge sum of money to somebody who had booked from November something to another, and I said, I don't want it. So I had to pay Verbal because I did that. And the guy went and left. I don't know. I never read it, because he never stayed in my place. So why would he have the opportunity to make comments on my page or whatever? So I made sure Verbal canceled, although the penalty was stiff. Initially in September I couldn't afford it. Because every time you cancel something, but eventually everything was canceled. Everything was canceled.
Thank you.
So I believe, I apologize, Councilmember Parker. Board Member Kabuchi just handed me his phone and that has the website address of the supposed ad, and there is something that appears to be active. And it says posted by Ezekiel.
What website is that?
It's Airbnb.
Airbnb?
Uh-huh.
Oh, no. Airbnb even gave me there's a calendar, you have to, darken it, and they did it themselves because I was trying to do it, but it wasn't very successful. I never had anybody. In fact, there's no way I could have anything. Today, did anybody indicate any interest in coming?
Let's see here.
So for some clarity,
It's impossible.
Yeah, go ahead.
You have
This is the ad. This is the ad on both Airbnb and
the ad is
Bible.
still active,
Yeah.
and someone can book
No, up to next year.
February 1st of 2022.
Yes, up to next. That was what I was allowed. You cannot book until then.
Right, but if your permit has been expired and you have been prevented from operating an Airbnb until, I believe the date was what, November?
Yeah.
September 1st of 2022? Why wouldn't you have just taken the site,
Just
taken it down?
September 22. Well, that was I was hoping that by then I would, extend it, every 3 months. I would cancel it because I wanted to, I think I wanted to still continue with Airbnb somehow, but I don't know when, but I just do. Cancel for 3 months, cancel for 6 months, then the next month cancel for 6 months again. Because I could cancel forever, but I don't know, that may not be practical.
Right.
I think to Councilmember Parker's point, though, is that we want to see from the appellant that you are doing, you are making the steps in the right direction to at least correct the wrong, right? And so, in my mind, it would have been a better move in your part to block off all of the potential opportunities for reservations until September 1st while you're talking with us.
Yeah.
before we.
I agree, absolutely. I agree. If I had, thought deeply, maybe that would have been the best thing to do. But I knew that I'll be revisiting the website to extend it from time to time until, I don't know what you guys would do. See, that's why I stopped at that.
Sure. Are there any other board member questions? If there are none, then we'll close the public hearing and begin the deliberation process. This is I'll say on the one hand, this is tough, and then on the other hand, for me, it isn't tough. I don't feel like Mr. Conde is a bad actor. However, I feel like, by his own testimony, he was aware in at least, no later than April or May of 2021 that there was an issue with the permit and that he wasn't operating legally, but then there was continuation. There may have, there was an affidavit in August, and then there were stays after that. So there were various points at which he was made aware, and that knowledge is sort of refreshed, and still no opportunity. And then there's an active listing, even though some of the dates are blocked off, they're not all blocked off. So there was an anticipation that he might get relief before the relief was granted. I don't find any cause to grant any relief from the 1-year waiting period.
I concur with that, and I just want to say, I sort of see continued activity beyond a permit expiration in different layers of maybe severity, we might say, after the appeal being filed, being sort of the most severe in my consideration. Obviously, if people make genuine mistakes, then they address them as quickly as they can in some cases, but I'm not seeing enough or any effort in this case to correct to support any relief. So I think I'm with the chair on this one.
Any other commentary? If none, I'll entertain a motion.
Mr. Bond, before you just for clerical sake, the 1 year penalty is from what date? Just so I can put that in the order.
Do we want to make it from the last documented stay, or do we want to make it from the date that the appeal was filed?
I would actually recommend from the date the appeal was filed, and I think only because of the fact that the appellant has at least closed some dates off. Mm-hmm. I think there's some grace in that.
Okay.
The appeal was originally filed what date?
September 28th. So would we want to just push it to October 1st in that case? Okay. I'll entertain a motion to that effect.
I would like to note one thing, that not having an Airbnb permit means that you cannot advertise or rent the property. So I would recommend for when you're able to reapply, I would recommend not having that listed prior to that application would be my recommendation to the appellant. That being said, I'll move that that no relief be granted and the year wait period begin September 28th, 2021.
Okay. Is there a second?
A second.
Okay. All in favor? Aye.
Aye.
Okay. Looks like the vote is unanimous. Mr. Akande, your request for relief is denied. You'll be eligible to reapply for a permit on October the 1st of 2022.
Mr. Akande, if I might say one other thing to echo Councilmember Parker's statement, I'll say it a little bit more clearly. You need to take the advertisement down to ensure your hopes of getting a permit when it's time for you to reapply for a permit. You can rent it for a long-term rental. You cannot rent it for short-term, but it would be strongly advised for you to take the advertisement down completely.
Well, I thought taking the advertisement down is canceling all those dates, because there's no advertisement. After you cancel the dates, you are not available anymore.
Well, Airbnb should be able to walk you through the mechanics of that.
Yeah,
we're not in a position to advise you as to what that is, what
exactly,
the effect of taking it down. But advertising without a permit is against the law, and it puts you in a bad position when you get to the point where you're ready to reapply.
Okay.
Thank you so much for your time.
Okay, Mr. Chairman, the next case is case 2021-30, Lease Killers, the appellant, Mr. Chimalam Okafor, the owner of the property at 4602C Georgia Avenue, seeking permission to apply for a permit earlier than the law allows. The appellant has alleged the appellant operated after the short-term rental permit expired. Is the appellant present in this case? Okay. Legal counsel, are there any parties here wishing to address the board either for or against? Which one, sir? Opposition. Okay. In this case, Mr. Klein and sir there in the back, you'll have 10 minutes to present your case when the time comes under these rules. So.
And just one point, if you would like to have any rebuttal, please reserve part of your 10 minutes. This is governed by Bill 2016-492, effective date 2/24/17, 1-year wait for advertising and operating with an expired permit. The board does have discretion to reduce the 1-year wait period. June 1st of 2017, Airbnb ad posted. June 27th, 2017, owner-occupied STRP permit was issued. September 22nd, VRBO ad was posted. December 16th of 2017, Flip Key ad was posted. March 8th of 2018, Booking.com ad posted. On June 11th of 2018, the permit was renewed. May 6th of 2019, the permit was renewed. On May 18th of 2019, the Booking.com ad was removed. On June 26th of 2019, the Flip Key ad was removed. On June 4th of 2020, the permit was renewed. On October 28th of 2020, the property was quitclaim deeded from Elizabeth Humphreys and Shimalam Okafor to Shimalam Okafor. Ms. Humphreys had provided the proof of residence during the owner-occupied permit application process during the prior to the permit being issued on 6/27/17. You'll have a typo there on your summary, but it was 6/27/17. March 19th of 2021, Metro Codes received a hotline tip alleging that the owner did not live at the property. This triggered a look at the permit. When it was discovered that Ms. Humphreys had provided the proof of residence, Mr. Okafor was asked to provide the required proof of residence documentation in his name. Mr. Okafor provided the requested documents, and in addition, he provided a proof of 2019 real property tax statement for 4602C Georgia Avenue, which is the short-term rental property in question, that listed Mr. Okafor's address as 270 17th Street Northwest, 2413 Atlanta, Georgia, 30363. However, since he did provide the proof of residence documents required by the Metro Nashville STRP ordinance, the permit was changed to show issued in his name because he was listed as one of the two owners on the previous deed for the property. On June 27th, 2021, the permit expired. July of 2021, there was one documented stay. There were a total of 6 documented stays after the permit expired. There were no documented stays after the notice of violation was sent, which was on September 21st of 2021 by Inspector John Phelps. Upon the reinspection on October 11th of 2021, the case was closed because compliance had been achieved. On October 20th of 2021, the STR Board appeal was filed, and on October 21st of 2021, the cancellation letter was sent. There were 2 documented complaints with the host compliance hotline. One of those complaints could not be directly attributed to this STRP. The other was previously mentioned. It was the hotline tip on 3/19/2021 alleging fraudulent owner occupation.
Does that conclude Metro's presentation? Okay. Are there any questions for the Metro representative from the board? Okay. In that case, welcome back, Mr. Klein. You'll have 5 minutes to make your presentation. That's 10 total, excuse me. Thank y'all for keeping me honest on these rules.
Thank you, Vice Chairman, and I'll reserve 5 minutes for rebuttal. Again, Mr. McBroom did a fantastic job surmising the events. I do not have anything to contest with regard to that. This goes back to your question, Vice Chairman, about the authority of the board to be able to reduce a 1-year injunction to a 6-month injunction. In this case, these facts do fit that mold where there was a permit issued. There was some questions around the ownership of the property and who was on title. Mr. McBroom was correct. Ms. Humphreys did quit claim her interest to Mr. Okafor, making him the sole owner. And that was the issue that came about on March 19th, 2021 with regard to the the proof of residency documentation and things of that nature. This is Mr. Okafor's primary residence. However, thereafter, the property management company for Mr. Okafor failed to renew the permit based on the change in ownership and the documentation that was requested. There was some confusion within their within Lease Killers internally on whether a new permit had to be applied for or whether that permit that was initially issued both to Ms. Humphreys and Mr. Okafor was valid given the change in ownership and the way that those laws work, because we know that a transfer will terminate a permit. However, in this case, there was not a transfer. Mr. Okafor maintained the ownership of the property. So in this case, this again would be requesting the same relief. In this instance, Vice Chairman, I would assert that the zoning administrator did err in imposing a 1-year injunction on this property, and that the correct injunction pursuant to MCL 6.28.030.A.5.1.6.2 states that upon a determination by the zoning administrator or the zoning administrator's designee that a short-term rental property is operated without having renewed a previously issued permit, there shall be a waiting period of 6 months from the date of such determination by the zoning administrator for the property to become eligible for an STRP permit again. So in this case, based on the current law and the laws that apply, we would request that the relief be that the relief requested would be to reduce the 1-year injunction to a 6-month injunction pursuant to the law as written, and for the fact that there was a permit previously issued for this property.
Thank you, Mr. Klein.
Mr. Klein, can you clarify for me? I believe that the address provided by Mr. Okafor was an Atlanta, Georgia address. You're saying this is his primary residence?
Council or board member, I cannot speak to, again, this is the first time I've heard of the Atlanta, Georgia address, so I wasn't able to ask my client about that or be able to bring facts.
Where's your client live?
My client lives here in Nashville.
Okay.
Yes. And he has other properties here in Nashville as well. Specifically, he has the property over in 1212, but that is not his primary residence.
What type of permit does the 1212 property have?
I'm not aware of that. Permit's not before the board today. I didn't pull any information on that.
If there are no other board questions for Mr. Klein.
And I'd reserve the rest of my time for rebuttal after opposition.
Noted. Okay, we'll go ahead and call up the opposition. That does not matter where you sit. Yes, button to the right.
Yes, my name is Nicholas Brindle. My address is 704 47th Avenue North, Nashville, Tennessee, 37209. I'm in the property that is, Georgia is on an alley, and my garage, basically my back porch faces the entire side of that building. And so I'm not entirely sure what the, pardon me, I'm a lawyer, what the angle is, the specific aspect being adjudicated or litigated today. I'm not going to come up here and just gripe about the Airbnb neighbor, and hopefully this isn't too tangential, but I've been in that house since July of 2019, and, you know, it was Airbnb, bachelorette parties, yada, yada. And it wasn't necessarily there was not much to gripe about. They were generally fine. If you can tolerate the noise, you know, outside during the day, not too bad. And it was only sort of around March of 2021 when there was an incident where somebody was, a gunshot was fired, basically in my alley. And it was basically around that same time, I started having to call lease killers like every weekend because I couldn't get out of my garage. It was being blocked. So in any event, when that happened, I have a 3-year-old, and my wife is pregnant with our baby now, is when I started looking into like filing complaints, yada, yada. And then at that point that I found out that this was an owner-occupied permit because, and not to just be too anecdotal, but there is no indication under any common sense neighborly view that anybody used that as their primary residence. I could not tell you what the purported owner looks like, could not tell you what car they drive. Like I said, that's where my garage is. So, and as I exit, I can see the parking in the back. I drive every day, wherever I'm going, whether it's to work or to the store or whatever. I take a left or right around it, see which cars are out front. The only car or anything that I've seen with any consistency over almost 2.5 years is cleaning people, maybe on a Tuesday. You know, and again, I know this is anecdotal, but you know, consistently see mail that's overflowing from the mailbox. But just, I mean, that's what at one point I was shocked. I was like, that's not owner occupied, you know, and I'm not going to get into what documentation needs to be shown. I know it's a bit more difficult these days after the state sort of eviscerated Metro's original, you know, regs regarding this, but there's no sign of that anybody uses as their primary residence at all. And then as for, you know, so that's sort of what I was here to discuss. Now I know the side issue is whether he should have known to reapply for his permit on time. And they already spoke to there's definitely been events that have occurred or people, you know, whatever sort of galas or whatever, for whatever reason, people are dressed up fancy walking in and out of the house with decorations or, you know, Venmo hashtags on the sides of cars for somebody's shower, etc. So like that's clearly not in dispute, I would think. To the extent that there's any confusion, I do note that the B unit is owned by somebody with the same same surname as the individual that owns this, and they reapplied for their permit fine, I believe, in March or May of this year, based on what I can tell. So I mean, and they're also managed by lease killers. So you know, not to jump in the seat of the city or the metro here, but I don't know what the history of that property is necessarily, but it would seem that, you know, as far as a good faith, something got messed up, I would hope that would somewhat argue against it. And then, yeah, that's all I really have to say.
Could we confirm your name again?
I'm sorry, it's Nicholas Brindle, Nicholas.
Okay.
Brindle.
Thank you. Mr. Brindle, as to the gunshot being fired, that incident, was there a police report filed? Did you call the police, or did someone else call the police?
I've got like a screenshot from where it was shown as being reported by, I think, like the lady that lives 2 houses down from me on my street. Mm-hmm. And I think I had submitted that at one point, but because of the fact that it was outside, it could not be, there was a police report, but I can't remember. I spoke with somebody, and I thought that would be a little bit more of an egregious violation, but I guess because it was outside, it couldn't be attributed to the party where there were, 10, 15 cars in the alley and 5 out front in front of the building. And when we came home the next morning, there was a car with a gunshot in the alley as we pull in to turn left. So, but yeah, it was filed. Like I said, we were, I can't remember what it is, but you can look it up to see what's been reported locally. But
And you also made mention of documentation that you didn't feel was of any value, but did you happen to bring it with you?
yeah, I think I've got a screenshot that's viewable. Again, it's
Not necessarily of the police report, but of other things that you said you documented that indicate that there's some untoward things.
oh,
going
that
on.
was the main one. Was just like that was a police report.
Gotcha.
That had been filed. Yeah.
Right. Okay.
Because it was only at that point that I started to because it's whatever. Airbnbs are somewhat annoying, I guess, but they're not. It doesn't bother us too much, and hadn't until then. And it was only until honestly, when COVID hit, it seemed like they were having illegal parties because there were just a lot of local cars, or a lot of Georgia. Sometimes there were Georgia cars, but and it wasn't like your typical cliched bachelorette party where they're a little bit loud in the afternoon, but then they go out and they're done. And the most obvious thing was all of a sudden I couldn't get out of my garage.
You said at one point that you were in pretty much constant communication with lease killers every weekend due to some things going on.
Until they eventually.
Did you ever transmit written correspondence to them demanding that they do something about it, or was this always phone calls?
It was just because it was at first, it was just it was just odd, and I had to figure out who actually got the property, called them, and to be honest, they would crack the whip pretty quickly, and turn around, basically the cars would move quickly, and I'm still puzzled why they would do it because there's a huge street with plenty of parking. But anyway, so yeah, I did not document it because I just kind of felt like it was a blip. And then it continued and continued and continued, and then everything quieted down after the gunshot incident, I'll say. And so I think a lot of it, my guess was just they weren't getting the regular clients, and so it was sort of taking whatever would come. And so as COVID sort of eased up and, sputtered along, kind of resumed at the whole, people rolling in on Thursday and, depending upon the weather, they'd be outside doing some stuff. But again, there's no signs that there's any one person that lives there. I mean, and it's not like I'm just, basing this on, driving by it once every week. I mean, especially during lockdown, my wife was pregnant recently, and just she was more leery, so I would be the one running errands, taking the kid to daycare, going out every time, and like I said, I can see the backyard or the back parking area, drive around the front. It's rare that during the week that there's any car there overnight at all. Again, I don't know how much. If this is relevant to your exercise of your discretion, then I will continue to tell you why I've never thought. And actually, I do have an adjacent neighbor who is owner-occupied at Airbnb, and I know his name. I mean, perhaps he's closer in proximity. He's just there instead of 50 feet across the alley. But I see him mowing his lawn, and it's okay if somebody wants to get somebody to do that. But I see him getting his mail. Recognize his car.
Right.
I recognize when he has somebody over.
Right.
Just all of the general common sense signs that would indicate that somebody actually uses that as their primary residence are there, and just simply absent with 4602C.
Well, thank you. I think you've painted a fairly clear picture for me. Any other board members have any questions for the public member? Okay. In that case, I believe, Mr. Klein, it's your opportunity to rebut.
Do we need to push this off once?
Yes. He's pressing
Mr.
once.
Vice Chair, before Mr. Klein's rebuttal, so that he can address this if he wishes, I do need to make one point of clarification concerning the reduction to the 6 months. I'm going to place on the screen the state law.
Yeah, that question was certainly coming.
Okay, this is me, this is Public Chapter number 972, House Bill number 1020. And the effective date for this, and this is the state law that governs all local jurisdictions as far as what they're allowed to do in terms of their ordinances for short-term rental permits. And the effective date of this was May the 11th of 2018. The highlighted section here, the ordinance, I'll just read it. The ordinance, resolution, regulation, rule, or other requirement in effect at the time the property began being used as a short-term rental unit is the law that governs the use of the property as a short-term rental unit until the property is sold, transferred, ceases being used as a short-term rental unit for a period of 30 consecutive months. Now, none of those criteria have been met in this particular case. And this permit was issued on June the 27th of 2017. That means that it is governed by the bill in effect at that time, Bill 2016-492, and that bill stipulates that operating without a permit or operating with an expired permit carries a one-year prohibition against applying for a permit. However, it does give the board discretion to lessen that period.
Thank you so much. All right, Mr. Klein, I believe the floor is yours.
Thank you. You going to join me or?
Thank you for your time, Mr. Brindle.
You're welcome to. And so, in rebuttal to some of these points, again, I would like to point out that Bill 2016-492 does give the board discretion to reduce the one-year waiting period from 1 year to a specified period of time. Some of the things that were highlighted or mentioned to the board are things that the Metro Code provides checks and balances to ensure things or allegations of someone not living at a property to be able to be vetted, and for the zoning administrator and or his agents to determine whether or not there is someone that lives there. Today, the request before you is to reduce the one-year injunction to 6 months. If the board were to grant that request, then upon 6 months from the date of, assumingly would be the last review, or when the permit was canceled. I know that there's been some talk about what those dates look like and when would apply, but upon the reapplication for a residential short-term rental permit, given that this property is zoned R6, it cannot be a not owner-occupied. Metro would then complete its full review and analysis of said application and determine if Mr. Okafor is the primary resident of that property. So that determination is not before the board today. The determination for the board today is whether or not we can reduce this one-year injunction to a 6-month injunction based on the law. And so, again, I would reassert that in conjunction with the law that Mr. McBroom pointed out that was passed in May of 18, along with BL 2016-492, and the ability to reduce and have the discretion to reduce the injunction, that again, we would request that the short-term rental property, the injunction on the short-term rental operation on the property be reduced from 1 year to 6 months in conjunction with MCL 6.28.030.A.5.1.6.2, and that upon expiration of said injunction, that then Metro will be able to adequately determine whether or not Mr. Okafor qualifies for a residential short-term rental permit. Outside of that, some other things to note. While I'm am sympathetic. I don't have children, but I have a niece, and I know how much that she doesn't like to be woken up. So I understand the opposition's point with regard to parties and gunshots and things like that. It's not anything that I would want my family to necessarily be around either. However, the proper course of action is to file a complaint, to have that complaint on the record, so that then when there are 3 complaints that can be attributed to STRP activity, that permit can be revoked. So I would encourage any opposition to do so in order to have standing to make said argument. But nonetheless, the facts that stand, as Mr. McBroom stated, there have not been more than 3 complaints attributed to STRP activity on the property. The property has not been not used as an STRP for more than 30 continuous months. The property was not transferred, as Mr. Okafor maintained ownership even through the quitclaim process, where he was then granted the entire ownership of the property. So given these circumstances, this is a case that in what I would allege would be ripe for a reduction from 1 year to 6 months. And then if there becomes a need to address these other issues that have been brought before the board that are ancillary but do hold weight, then Metro has a process in place to attack those at that time. Are there any questions from the board that I can address?
Board members, any questions for Mr. Klein?
Mr. Klein, you don't dispute that there were 6 documented stays after the permit was expired in 2021, correct?
No, ma'am, I would not. And back to Councilman Parker's point about the different steps and the cancellations, in this case, once the STRP appeal was filed, there were no stays thereafter. So as I think he notated in the previous appeal about the different stages on where stays that were, when they occurred, when they were notified, did they take time, did they do anything to mitigate that or to cancel any further stays, or did they have stays even after that? And in this case, once the STR board appeal was filed, there were no more documented stays after that. And I think I addressed that, Board Member Kimberly, on page 3 of my, and in fact, it looks like that I had more notated stays than were actually listed. So yes, I do acknowledge that. But as soon as on or before the filing of the BZA application, there were no more stays thereafter.
Any other questions from the board members for Mr. Klein?
And Vice Chairman, I did not give my address before I started this appeal. Do I need to do that for procedural purposes?
We took note of it when you
Again, my name is Seth
Yes.
Klein. I am representing the lease killers in case STR 2021-030. My address is 1811 Fatherland Street, Nashville, Tennessee, 37206.
Thank you. If there are no other questions from the board members, we'll close the public hearing and begin deliberations.
I don't know that I particularly see a mitigating factor present in this.
Yeah, I don't think I do either. The only thing that I saw that might have been at one point was there was some confusion, but if there is another unit for which they're doing the exact same thing, and also this is one that's been operative for 3 years before it expired, and it seems like if there was any confusion to resolve, they would have resolved it in March whenever there was a question as to who was living there and figured out what the requirements were applicable to Mr. Okafor as the sole owner of the property. So I'm not inclined to grant any relief either.
I agree. I still have a problem with the confusion over the owner-occupied permit as well. Its permit was renewed 3 times previously. There were 6 days afterwards. Yes, there, the ads were removed after the notice of violation was sent, and they were deemed to be in compliance in October. But there's, as you pointed out, Mr. Bond, they're operating more than 1 unit. Yeah. They should know the rules at this point.
Absolutely.
To add to that, I think that the Lease Killers website specifically says that they manage the process of the exhaustive process of permitting. So if they can't handle it, then.
All right. In that case, if there is a motion, I'll entertain it.
I would also, before we move to that, I'd like to ask if we can we give direction to zoning? Can we give direction to zoning as well? To ask them to do a little bit more research around the owner-occupied component?
I had a question around that for staff, although it's, not directly related to the matter at hand. Because it's been touched upon, which iteration of the code this occurred under. I'm curious, when owner occupancy was determined under 492, when this person reapplies, would the standards of documentation have changed based on the code changes in the meantime?
To the extent of what you have to show to prove owner occupancy, they will run under 492. The standard that I use is the standard that I use to determine residency is an old case. It's from 1916. It's still valid law in the state of Tennessee. It talks about a man's domicile. And I just had it on the tip of my tongue. I apologize. It's Denny versus Sumner County. But the court case, and forgive the gendered language, but it says that a man has but one domicile but can have many residences. So a domicile is your home, and that is your home until you abandon it and establish another. That's the standard I use today. You will see cases in the future where they claim to live here. So I guess to the extent of counsel sitting here or any other potential applicant to this board, I take the residency requirement quite seriously. I don't play a game of, well, I stay over here sometimes, and then I'm over here for a few months. You've got one home. So if it's here, pick it. If it's not there. So when we look at these applications, the ordinance talks about two items of identification of the principal residence, but we have other documentation showing you elsewhere. I'm going to deny the permit and bring them to this board to let them appeal. But to your question of what metro ordinance does it apply under, it's at the time the permit was issued. So if that standard, say, only required one piece of documentation, I don't just check the box and move on. We're looking to check that you do reside here. So let that be forewarning of anyone else out there. That's what we're looking for.
I think in this case particularly, thank you so much, Mr. Harkins. I think in this case particularly, I'm looking at the Assessor Properties website, and there's a lot of other mailing address for the owner, which is the appellant, Mr. Okafor. It shows his mailing address as the same address as 1212, yet the property information for this address, 4602 Georgia Avenue address is something in Atlanta. So I think it's just important to note that for on the record.
Before the board acts on this, I do want to warn you, in no way should that govern your decision here. We will look at that at the time they reapply. Right. So I do implore you on the record to not let that weigh against this applicant.
Right. I'd like to say that I think it's
clarifying.
Yes, I think it's important to acknowledge they're not necessarily weigh in our decision making when neighbors come in to testify about a given property. I think it's important to acknowledge what they bring up, but we do have a very narrow scope of decision making here, and I'll just echo what everyone has said to stick to that.
Okay. So if there's a motion in waiting, I'll entertain it now.
From what date?
Yes, that is something that also needs to be decided.
What's the appeal?
To my mind, it's the date of the appeal, or either October 1st or November 1st, and I would say November 1st.
That works for me.
Okay. If that's the case, then I will make a motion that we deny relief and deem the appellant eligible to reapply for a permit no earlier than November 1st, 2022.
For point of clarification,
Yes.
Mr. Bond, and so that we are consistent, did we, for lack of a better term, roundup from the appeal date on our
We
last
did.
decision? Okay, I just wanted to make sure that we were
Yes,
consistent with that.
yes.
Seconded.
Okay, the question is on the floor. All in favor? The decision appears unanimous. Thank you for your time, Mr. Klein. Mr.
Okay, Mr.
Hargis,
Chairman,
I believe we're ready
the,
for the next matter.
Yeah, the next case, case 2021-33, Keith and Kristen Carter, the appellant and owner of the property at 2118 9th Avenue North, seeking permission to apply for a permit earlier than the law allows. The appellant operated the short-term rental permit, operated after the short-term rental permit expired. No, the appellant's present. Are there any parties here in opposition to case 33? Mr. Chairman, I see none. Ms. Carter, you'll have 5 minutes after Mr. McBroom completes his testimony.
Again, this bill is governed by 2019-608, the effective date February 2nd of 2018. 1 year prohibition from obtaining a permit for advertising and operating with an expired permit or without a permit. And the board definitely has discretion to reduce the 1 year wait period. On December the 7th of 2019, owner-occupied STRP permit was issued. On June the 26th of 2019, Airbnb ad was posted. On May 20th of 2020, the permit was renewed. On September 25th of 2020, a VRBO ad was posted. June 7th of 2021, the permit expired. This came to me, this address was forwarded to me on a list of short-term rental properties who are advertising and operating either without a permit or with an expired permit in September of 2021, which is provided by Metro's compliance contractor, Gronicus Host Compliance. On September 14th of 2021, I sent a notice of violation for advertising and operating with an expired permit. On October the 12th, I received an email from the appellant, and it stated, I dropped the ball in sending my permit renewal in on time. I immediately unlisted the property and sent in the affidavit and check on September the 14th of 2021. Was it received? Is there any more I need to do to regain my permit? I responded, the permit expired on 6/7 of 21. The Metro STRP ordinance provides for a 30-day grace period from the date of expiration, which ended on July the 7th of 2021. Since the date of expiration, there have been at least 5 documented stays, and I checked with the zoning examiner that issues the permits and renews the permits, and was told that you're currently under a 1 year prohibition from applying for a permit. The Short-Term Rental Board of Appeals has discretion to lessen that time, and you'll need to file an appeal with the Short-Term Rental Board of Appeals if you wish to seek to have the 1 year reduced. On October 21st of 2021, performed the reinspection and host compliance tracking recorded that the ads had been removed on September 16th and 18th of 2021, which were well within the remedial time period, and I closed the case. On October 25th of 2021, the STR Board appeal was filed. There were 5 documented stays after the permit expired, and there were no documented stays after the notice of violation was sent. There were no documented complaints for the property in either the Metro Hub or with Host Compliance Hotline.
Any questions for Metro from the board? Okay. And we'll now turn our attention to the appellant. If you'll please identify yourself and state your address, please.
Hi, I'm Kristen Carter, address 4408 Leland Lane, Nashville, Tennessee, 37204.
Thank you for appearing. You'll have 5 minutes to address the board.
Okay. So I had a property manager managing our Airbnb, and I decided to take it over myself, and there was just confusion in renewing the permit, and I just, it was my bad. I should have known it was going to expire, but I didn't realize it expired until September, and as soon as I realized it, I took everything down, and I'm just asking that the board lessen my waiting period so I can restart my permit sooner than 1 year. I was hoping 3 months from when I file my appeal if possible.
Okay.
That's really all it is. I don't have any fancy codes to cite. I just, it was my bad, and I'm just asking for a lesser time, waiting time.
Understood. Board members, if there are any questions?
Ms. Carter, is this your only short-term rental?
Yes, it's my only one. It's my first time ever running one, so.
Thank you.
Any other board member questions?
I'd like to clarify, you have an owner-occupied permit?
No.
I guess, can we get clarification from the staff? I think the document I'm looking at, it says that it is an owner-occupied permit?
Sure.
Yes, I apologize. I did state that this was an owner-occupied permit. It is a multifamily, not owner-occupied permit.
Thank you.
If I may, I see that you received a notice of violation on September 14th, and then you immediately, it looks like you sent your affidavit and check on that day, and then the ads were removed September 16th and 18th. Did you have to cancel any stays as a result of, you did? Mm-hmm. Okay. Thank you.
Any other board member questions? Okay. If there are none, then we will close the public hearing and begin deliberations. I think there's good evidence that there is an immediate attempt to comply, so I'm fine with the reduction.
Agreed.
I agree. I think that this is her only Airbnb. She has not managed this on her own before, and the immediate compliance are all mitigating factors.
And the appellant has requested a period of 3 months. I don't find that unreasonable. That would put her at January the 25th.
Agreed.
Agreed.
All right. Well, if there's a motion. Well, let me make the motion just to make it clear on the record. I move that we grant the appellant's request for relief and deem her eligible to apply for a new STR permit on January the 25th, 2022.
Thank you.
Second.
All in favor? Aye. The decision is unanimous. Thank you, Ms. Carter. You'll be eligible to reapply on January 25th.
Okay, the next case before us, case 2021-34, Kimberly Cox, the appellant, and owners of the property located at 2420 Brittany Drive, seeking permission to apply for a permit earlier than the law allows. The appellant operated after the short-term rental permit expired. Ms. Cox is present. Any other parties here wish to address this board on the case? Mr. Chairman, seeing none, we'll have 5 minutes to present. Oh, sorry. Oh, do you want to speak to the thing? Yeah, feel free to come on up. No opposition present, so you'll still have 5 minutes, Ms. Cox, after Mr. McBroom completes his report.
This is which one?
This permit is again governed by 2017-608, February 2nd of 2018 effective date. And the board has the discretion to reduce the one-year waiting period. August 29, 2018, owner-occupied STRP permit was issued. On October the 5th of 2018, a VRBO ad was posted and a flip key ad was posted. On October 9th of 2018, Airbnb ad posted. August 16th, 2019, the permit was renewed. January 16th of 2020, Booking.com ad posted. March 24th, 2020, Booking.com ad removed. August 4th, 2020, permit renewed. On August 29th of 2021, the permit expired. There was a notice of violation sent by Inspector John Feltz on October the 20th of 2021. On October 25th, there was email correspondence between the appellate and the inspector. On October 26th, the STR Board of Appeal was filed. And then on November 21st of 2021, the reinspection. The 3 remaining ads were adjusted to a 30-night minimum stay, which moves it to a long term. There were 3 documented stays after the permit expired, and there were no documented stays after the notice of violation was sent. There were no documented complaints for the property on either the Metro Hub or within the host compliance hotline. There was one concern for the property. The expired permit is an owner-occupied permit, and the appellant and her husband also own 2904 Nocturne Forest Drive.
One question. Do we have a copy of the correspondence between the appellant and the inspector? Okay.
No, Mr. Vice Chairman, I do not.
And are we familiar with the contents of those exchanges were?
Yes, sir. Basically, she indicated that she had received the notice of violation and wanted to know what she would have to do in order to renew her permit. And the inspector informed her that she would have to remove her advertisements, cancel her future bookings, and file an appeal with the Board of Short-Term Rental Appeals.
Thank you so much. Any other board member questions for Metro? All right, Ms. Cox, you now have the floor. If you'll identify yourself and state your address, please.
Yes, my name is Kimberly Cox. I live at 2420 Brittany Drive, Nashville, Tennessee, 37206. I would first like to thank you all for allowing me the opportunity to come here to request that I renew my permit earlier than the law allows. On October 25th, I received notice that the permit had expired. The violation had to be removed or be corrected by November 20th. This was shocking to me because I mailed in the information for the renewal in July. On the 26th, I came to the Codes Department and they informed me that I could not renew the permit at that time and that I would have to file an appeal in order to get the renewal time decreased from 1 year to 6 months or whatever. I immediately contacted the advertising company, and they told me that it would take a while for them to stop the advertising, but I could do as the board suggested, or as code suggested, to go to a 30-day minimum because they could change that for a couple of days, and that's exactly what I did. I had 3 bookings after the time I received the notice, and those were canceled immediately. Prior to the 25th, I had not received any correspondence regarding the permit or the permit expiration or the renewal. In the past, I would send the information in or I would bring it down, and we didn't get any receipt or anything like that. So I just assumed that the permit had been renewed, like it always have. And like I said, that was an oversight on my part because I should have checked the documentation online to make sure that they had renewed the permit. I had not unknowingly operated the permit, knowing that it was a violation or purposely. I assumed that this violation, I assumed that the permit was already in effect and that I had not known that this was a violation. I take responsibility for not following through to make sure that the permit renewal and the information was received timely manner, and I hope that you consider my attempt to renew the permit before the expiration date or my efforts remedially in complying with codes in a decision to allow me to apply sometime hopefully within the beginning of the year if possible.
Thank you so much.
Thank you. Oh, I did want to say something. I forgot to say something about, reason why she's here, because when I put the information in the mail, like I said, we just put stuff in the mail, come and go. I had no idea that there may have been issues with the mail until I was talking to the neighbors about this situation, and they told me that there were still issues with our mail. So I'm thinking there may have been some, something going on with the processing of the mail is the reason why you all did not receive the information.
My name is Yolanda Flint. I live at 2424 Brittany Drive, which is next door to Ms. Cox. Mm-hmm. And I just wanted to say that since the tornado, we have been having issues with mail. Mm-hmm. Like, I'm waiting on 2 Discover cards from 3 weeks ago, and Discover keeps calling me saying, why haven't you activated your cards? I said, I haven't received them. Mm-hmm. And I also am waiting on Social Security cards that I put in the mail in July, and I still don't have them. Can't get my passport back or anything, but they keep saying, we've mailed your passport. So we have been having issues with mail since the tornado. Sure. Nobody's mailboxes were torn down or anything, but it's just like literally since the tornado, we are having issues with mail in our neighborhood. And I mean, I am for her getting her, short-term rental property going again.
Mm-hmm. Understood. Thank you so much for appearing and sharing that. Does the city have some?
Yes, I'm sorry. I apologize. I do have to make a correction. Again stated, this is an owner-occupied permit. It is not. It's a multifamily type 3 permit.
Might I ask of the city, and this may not be the appropriate juncture to ask, but could we actually start getting a copy of the permits in the packet so that we can eliminate any confusion as to what type of permit was issued? Thank you.
Did you have a question?
I didn't understand what he said about what he was saying about the permit.
He was making a correction as to the record as to the type of permit that was issued. It was a multifamily permit and not an owner-occupied permit, as is stated in our materials. Are there any questions of the appellant from the board members? There are none, then we will close the public hearing and begin deliberations. I see this situation very much similar to the last one. I think there is immediate attempt to comply, very open acknowledgement of responsibility for, making sure that the permit is active and stays were canceled. So and she also requested relief around the beginning of the year, and given the application or the appeal file date, I think that's reasonable. So I would make a motion that we allow the appellant to reapply on January the 26th, 2021.
Second.
All in favor? Aye. All opposed?
I'm for that. I was saying something. Oh, right. I just wanted to double check that night. I missed about
January the 26th of 2022? And I may have misspoken and said 20. I don't know what year it is. COVID has screwed me up completely. All right, well, it looks like the vote is unanimous. Thank you, Ms. Cox, for your time. You'll be eligible to reapply January 26th of 2022.
Thank you all for your time also.
Mm-hmm. Okay.
Okay, Mr. Chairman, the next case before this board, case 2021-35, Robert K. Butler is the appellant owner of the property at 2452 Eastland Avenue, seeking permission to apply for a permit earlier than the law allows. The appellant operated short-term rental permit after the short-term rent has expired. Is the appellant present for us today? Mr. Chairman, I'm not seeing any.
All right.
If you don't mind, just for purposes of administration, let's heal this case. I'll look at your rules and see administratively what we should do, whether we withdraw it or postpone.
We'll move this to the heels of the docket?
Yes.
For reconsideration then? All
right. Then the next case, case 2021-037, Daniel Walther, appellant and owner of the property located at 409A and 407A and B High Street, seeking permission to apply a permit earlier than the law allows. The appellant operated prior to the legally required short-term rental permits being issued. Mr. Klein is present. Are there any parties here in opposition to case 37? Okay, we do have one party present who wishes to speak, so each side will have 10 minutes to present their case to the board after Mr. McBroom presents his report.
And we will be taking A and B together, I would assume?
That's correct, sir, yes.
Okay.
Yeah, actually, included in this case are 409A and, 407A and B and 409A.
Okay. Oh, yes, I see that. My apologies.
This is an OR 20 zone district, which at the time the permit was applied for had not owner-occupied permits available and still does to this point. This is, in this case, it's governed by 2019-6, and the board has no discretion to lessen the one-year prohibition to apply for the short-term rental permit. In this case, the decision for the board is whether or not the zoning administrator erred in denying the permit based on the evidence that the property was advertised and operated prior to obtaining a permit. July the 30th of 2021 for 407A High Street, the application for a not owner-occupied permit was filed by the appellant. On August 10th of 2021, Metro Hub complaint filed for advertising and operating without a permit. On August 31st of 2021, the complaint was processed and 4 ads were found posted for the property, one of which had 3 reviews on this date of the month of August 31st. On September the 10th of 2021, during the review of the property records in preparation for the fire marshal's inspection, zoning examiner Robert Osborne saw the violation and canceled the permit application. Mr. Walter received the notice of violation and called. I told him that the information contained in the application packet prohibited applicants from advertising and operating until the permit is issued. I told him that the ads had to be removed and future bookings canceled prior to September 27th, 2021 to avoid further legal action. He wanted to know who to contact about the cancellation of this application. I suggested that he emailed zoning examiner Robert Osborne, as he was the examiner processing the application. I then spoke to Mr. Osborne and informed him of what had transpired. On September 27th of 2021, the reinspection was performed and found that the 3 ads had been removed. The 1 ad that remained had the calendar set for a 31-night minimum stay. On October 22nd of 2021, the STR appeal was filed. On December 1st of 2021, in preparation for case summary, I reviewed the website ad for the property, and as of 12/1/2021, there are 6 reviews for the property. The 3 August reviews previously mentioned, 2 September reviews, which were within the remedial time period allowed in the case, and then there was 1 November review. Now, submitters of reviews are allowed 2 weeks in order to submit their reviews, so it is possible, in all fairness, that stay occurred in September within the remedial time period, because the reinspection date on this case was September the 27th. 407B High Street, July 30th, 2021, application for a non-owner-occupied permit was filed by the appellant. On August 10th of 2021, again, the Metro Hub complaint was filed for advertising and operating without an SDRP permit on August 31st of 2021. Complaint was processed. 2 ads were found for this property, one of which had 4 reviews on this date of the month of August 31st. September 10th of 2021, the permit application was canceled. On September 28th of 2021, the reinspection found that 1 ad had been removed. The 1 ad that remained had the calendar adjusted for a 31-night minimum stay. October 22nd of 2021, the STR appeal was filed. On December 1st in 2021, preparation for this case are reviewed. The website ad for the property. As of 12/1/2021, there were 6 reviews for the property. 4 August reviews previously mentioned, 2 September reviews within the remedial time period.
Any questions for Metro from board members? Oh, I apologize. That's right. There are 3 of these. My bad.
409A High Street, again, July 30th, 2021, application for not owner-occupied permit was filed by the appellant. August 10th, a home complaint was filed. October 31st, it was processed. 2 ads were found for the property, one of which had 3 reviews on this date of the month of August, August 31st. September 10th, the permit application was canceled. September 28th, 2021, the reinspection found that 1 ad had been removed and the 1 ad that remained had a calendar set for 31-night minimum stay. October 22nd, 2021, the STRP appeal was filed. On December 1st, 2021, again in preparation for the case, I reviewed the website ad for the property. And as of 12/1/2021, there were 6 reviews for the property, 3 August reviews, previously mentioned 2 September reviews within the remedial time period, and again a November review, which again possibly could have occurred, the stay could have occurred in September.
Any questions for Metro? All right, if none, we'll hear from Mr. Klein.
Thank you, Vice Chair. Seth Klein on behalf of the appellant, David Walther. My address is 1811 Fatherland Street, Nashville, Tennessee, 37206. This is case number STR 2021-037. I would like to reserve 5 minutes of my time for rebuttal. The appellant in this case this is his first time applying for short-term rental permits, and first time going through this process. He is the owner of the properties located at 407A, 407B, and 409A High Street, Nashville, Tennessee, and Davidson County, Tennessee, 37211. It is certainly an area that is an up-and-coming area and part of Nashville. As I drove to place the sign for this STRP board appeal, it was very clear that the appellant had sought out a place to invest in and for the future rental income potential, and that it certainly has been what seems to be a welcomed addition to the neighborhood based on the current setting as is. But nonetheless, Mr. Broom acknowledged that on June 30th, the appellant applied for residential short-term rental permits for the property. On July 13th, the appellant sent the applications through a zip file. They could not be accessed. So on July 30th, he resent those. And then, on July 30th, he received documentation from Metro to continue the permit application process and was issued temporary permit CASR numbers T 2021-048490, T 2021-048508, and T 2021-048516. After review of the website, on Metro's website for looking for what exactly a temporary permit was, again, he was navigating this process on his own and his first time. There's not a lot of information regarding temporary permits because it's a question of whether or not they exist or not. But nonetheless, I think as we go through here, we'll see that there may be something to the existence of said temporary permit. Nonetheless, the appellant, as in the other cases I've been before today, advertised the property without having completed the full process. However, he advertised the property with the temporary permit numbers in this case, and he displayed those on the listings, errantly believing that the action to be within the confines of the laws that govern short-term rentals. He did not know that that was a violation of the short-term rental laws, and he did not understand that advertising the temporary permit was considered advertisement without proper permitting. At the time the appellant requested the fire marshal inspection, and before the inspection reports were returned, the appellant received the notice to correct the violation from Metro on September 6th. That was dated October 31st. On September 10th, believing that the notice was as a result of the failure to submit the fire marshal inspections, he submitted that documentation to Cindy Story of Metro Codes, who then replied to the appellant and informed them that the temporary permit was in fact canceled. The appellant spoke with the property standards inspector, Mr. McBroom, and was informed of his misunderstanding of the 90-day temporary permits that were issued. Once put on notice, the appellant immediately ceased any advertisement of the properties or changed them to longer than 30-day durations. The appellant does acknowledge that there were reservations made prior to September 6th notice that were honored thereafter through September 10th, but not after September 27th, the date specified to correct the activity, and that there were no other advertisements after or stays after the filing of the STRP appeal application. In this case, again, it comes down to a first-time individual not using a property management company, trying to navigate the short-term rental process himself. He got the short-term rental permits. They said temporary. He believed that they to be the permits for the property. When he got that, when he got those permits, and then when he got the notice to cancel, or the cancellation notice of the permits, he attempted to meet with Metro Codes in person and made multiple opportunities to try and contact them to figure out how to rectify the situation. But because of COVID policies, he was unable to do so. There were no more in-person meetings. As a result of that, Mr. Walther canceled $17,000 worth of reservations in order to try and rectify this, in order to get his permit. And further, since he received the notice that he's been leasing long-term and providing housing to Afghan refugees through 3 families of the Catholic Charities and Empower Nashville renting program that they have. So Mr. Walther is trying to make an effort to show that, one, he acknowledges his mistake and acknowledges that he that used these temporary permits under the guise that they were active permits. And because of these errors, that he would request that the ban on the operation of short-term rentals be reversed. Given the stance of our previous cases and the questions, I think in this instance, I would say that the appellant would allege in this instance that the zoning administrator did err and that the permit should be issued. However, again, I know that is a contentious allegation, but given the facts in this scenario, there was no property management company involved. We did have temporary permits that were issued. All other things taken in consideration, these permits would have been issued. They would have been proper permits. And again, as soon as Mr. Walther, who was navigating this by himself without legal representation, without a property management company, and in a neighborhood that certainly could use the development, I think. And whereas other areas are getting really focused on, I think that the High Street area and the specific zip code, I lived over there during law school, and I know some of the things that go on in that area. It can be quite dangerous at times, but I think Mr. Walther, and based on the properties themselves, if you looked at pictures of the properties, which I think is included in the zoning administrator's packet, these residences are not meant to be for long-term residential use. That's not. They are where they are positioned in the neighborhood and the way they are structured, the floor plans and the layouts. These are suited for transient occupancy. And so given these facts, I'd like to answer any questions the board has at this time, and certainly draw any distinctions between this case and the previous cases that I've been heard on today as well.
Sure. Mr. Klein, laying aside any potential considerations about economic impact on the neighborhood or potential mitigating factors, there's no argument that the properties were advertised before a permit was issued, correct?
I cannot say that, sir. No, sir.
Okay. I just wanted to make sure that I was clear on that. Any other board member questions? Okay. Then we'll hear from the opposition.
Thank you. I'm sorry, how long, Councilman?
Hi, thank you for coming in. If you'll identify yourself and state your address.
My name's Heidi Carter. I live at 1031 Antioch Pike, Nashville, in Woodbine. All right, I have it here on my phone, some notes. So I recently purchased a house. I live on 1031 Antioch Pike now, but as of today, actually, I signed on a street, on High Street, right next door to the 409 and 407, which the next one, it's the same, 409B, 409A, commenting on this. It's the four properties on High Street right there. I bought the house right to the right, 411 High Street. So I guess I just have three main concerns with this. The first is the integrity of the neighborhood. I've lived there since 2015, and if you drive around, actually, it's all just keep single-family zoning signs everywhere. It's there's not a lot of short-term rentals, and there's a lot of families and schools. Is actually this street specifically is highly residential. There's a school zone around the corner. I guess as Nashville grows, the direction that we grow with the short-term rentals is what concerns me the most, placing them in the residential areas. And I would agree that they're built, the way that those are built for transitional housing, perhaps. I just get concerned for the push, expediting the process. So the house that I just purchased is a part of 4 new builds, and they weren't unfinished during the time that they were operating this STRP. And when I was house hunting, I was curious about my potential new neighbors, so I just Googled it, and they were on Airbnb, and they were on, like, I could have rented it out. And so I guess my house was unfinished when they were operating prior to the permit, and then I just feel it's my due diligence to question that, push for a permit. And then third is the property is located across from 3 different religious institutions. It's the Radnor Church of Christ, and I can try to say these if you would like me to, but they are 2 Spanish churches. And I guess that is my biggest concern, but thank you.
Thank you so much.
Yeah.
Are there any questions? If none, then I will allow Mr. Klein to exhaust his remaining 2 minutes if he has anything more.
So, Vice Chairman, I understand that this case is governed by BL 2019-6, and it specifically states that the board has no discretion to lessen the 1-year prohibition to apply for an STRP permit. I understand there's not a lot of wiggle room here. I've been presented with some tumultuous fact patterns today to try and overcome the burden of proof, but nonetheless, just in short, we would reassert that given that this is Mr. Walther's first time applying for a short-term rental permit, the fact that he accomplished all other steps in order to obtain the permit and would have otherwise been permitted to obtain said permit, that it would seem that it would be I guess, splitting the baby, if you will. That's where I fall on the reducing to 6 months, but that's clearly not an option. So in this case, we would request that the board find that the zoning administrator did err and reduce the 1-year injunction, allowing Mr. Walther to apply for permits for these properties at 407A and B and 409A High Street upon the conclusion of this hearing. I'll be more than happy to answer any questions from.
Are there any questions of the board?
I have, just because this is not directly related to the appeal, but if you could entertain a question about, I saw in the email referenced an attached email explaining why this property was not subject to the 100-foot waiver requirement.
I know what you're referring to, Councilmember Parker. That was something with regard to, and to be quite frank with you, I don't want to lead you astray or give you the. I am too, and it's actually something that I put notes down to follow up on, because it seems like I think maybe staff might be able to answer that question, maybe Mr. Hargis. But what I'm guessing is that there is and this is strictly guessing, is that there is a waiver or an exemption for having to submit notices. Let's see. Please note that the properties are within 100 feet of a church. I understand that from previous communications that these are exempt from that rule per the attached email. What I believe that is addressing is when we have to send out adjacent mailer notification letters whenever we're applying for an STRP permit, so you can either use Parcel Viewer, and there's a tracer function that Metro has where you can draw a circle outlining the properties. And from what I would imagine, and again, this is pure conjecture, but I would venture to say that because it's a church, that letters don't have to be sent to the church, therefore that there were not the affidavit swearing that the letters had been sent out and the accompanying letters didn't include that. But again, Mr. Hargis or Mr. McBroom may be able to speak to that more so than I can.
Thank you.
Yes, sir.
I'm just curious. Thank you.
Likewise, I'd like to know the answer as well.
All right, if there are no other questions, then we'll close the public hearing and open deliberations. Acknowledging that Mr. Klein is in an unenviable position as to this particular case. I don't think that we have any discretion, and I think that I don't think that the administrator erred. There's nothing to support and overturn.
If I may, here we go. Yeah, I'll speak to just a little bit about the law that governs this. I mean, I was the second sponsor on this bill, if I remember correctly, 2019-6. And you know, the intent certainly was not for us to find ways that the zoning administrator had erred. The intent was actually to reduce the discretion. And I understand. Again, it's an unenviable position. The only question that I have for staff is this question of the T-numbered permits. If you could tell us a little bit about at what point are those T-numbered permits created, and when does it go from being a T to a regular permit, and then what does that T-numbered permit entitle a applicant to?
Okay. The T on permits, our permitting software, which is used not only for short-term rental, but all building trade permits. T is a temporary number. On the applications itself, if you were to print that application out, it says specifically, this is not a permit. So it's a temporary number assigned to this request for a permit application. And once issued, that T drops off. So the issuance of the permit is what converts that from a temporary with that T number. The T drops off. The number remaining is the actual permit number. But the T there for us is both internal and external. If you print that application out through our e-permit site, it says this is not a permit. It's an application. It's, you know, those types of things. But that's
a means to track, then, you would say?
It is. It's basically just a pending number out there that Metro departments look at to sign off on building permits. But as it relates to the distance to religious institutions, the council bill I show is 2019-78 that was adopted by the council in July of 2020. It says that no new short-term rental permit, non-owner occupied, shall be issued to an appellant whose location is less than 100 feet from a religious institution, unless, and I'm paraphrasing here, unless the council approves an exemption by adoption of a resolution through the city council, kind of akin to the old beer puds that you guys did. that sort of process, if I remember.
Sure. There was correspondence indicating that this property was exempt despite being adjacent to religious institutions. And again, we're off of the scope of today, so I apologize and thank you for indulging, Mr. Klein. We can discuss that offline if you'd like, Mr. Argus.
I'll be happy to look into it as far as correspondence from my office that you might be exempt. Just to get that to me.
Actually has to be excused, so if you don't mind, I'm going to go ahead and hasten the vote.
No worries.
If there is a motion to uphold the decision of the administrator is not in error, I'll entertain that.
I'll move that the zoning administrator did not err.
Second. All right, all in favor? All right, the decision is unanimous. The zoning administrator did not err, and the permission to grant, actually, there's going to have to be some specificity about this because there are different dates. There are different dates governing them, are there not?
No, these are all under -6.
Okay.
These are newly constructed.
Okay, so they're all 30-day, they're all a year from the date that the appeal was filed.
I believe it was September 10th that was in the staff's emails.
That was the date from the date of the cancellation. All right, perfect. They'll all be eligible for reapplication 1 year from the date that the permit was canceled. Just wanted to make sure we were clear on that.
Thank you. We'll enter the first order.
Okay.
Chair, I know Member Kimberly leaves. The final item on our agenda are an amendment to your rules under the notice provisions.
Joey, before you get into that, I think Mr. Klein may have a question.
I just wanted to get a date on the record specifically. I know it was 1 year from the date of cancellation, but just for the sake of the record, if we could get the actual date.
Sure.
September 10th, 2022.
Thank you. Yes, sir. Thank you, Vice Chair, and I apologize, Mr. Hargis, and I will be quiet.
Mr. Klein, we appreciate you giving us half your day.
Thank you, sir.
Yeah, she has to go though. We're going to do the rules before we leave. Yeah. Oh, that's right. We do have a case put on the heels.
There's one additional appeal which is related to these. It is the 409B High Street, basically the same information concerning it. July 30th, application for non-owner occupied permit filed. On the 10th, the hub complaint was filed for advertising and operating without a permit. October 31st, the complaint was processed. The one ad was posted for the property, which had 2 reviews on this date of August 31st, 2021. September 10th, 2021, the application was canceled. September 28th of 2021, the reinspection found that the ad remained posted with a calendar reset to a 31-night minimum stay. October 22nd, 2021, the appeal was filed. December 1st, 2021, in preparation for this case, I reviewed the advertisement, and as of 12/1/2021, the ad had been removed on 11/29/21. The last cached screenshot from the ad from 11/22/21 had 5 reviews for the property. And the 2 August reviews previously mentioned and 3 September reviews within the remedial time period.
Any questions for Metro? If none, then we will hear again from Mr. Klein.
Good afternoon, Seth Klein on behalf of the appellant, Adam Hallman. My address is 1811 Fatherland Street, Nashville, Tennessee, 37206. This is case STR 2021-038. This case is identical to the previous. The reason why these cases were separated is because Mr. Walther was the owner of 3 properties and Mr. Hallman is the owner of the other property. For the sake of the record and for the sake of my client's wallet, I'm going to go through and just briefly outline the purpose of this appeal. However, I do know the likely outcome and that any questions will be directly related to the previous case as well. I didn't know if there was any opposition to this matter. If so, I'd like to reserve 5 minutes for rebuttal. Mr. Hallman is the property owner of 409B High Street, Nashville, Davidson County, Tennessee, 37211. Mr. Walther, in addition to applying for the previous permits for 407A and B and 409A, also applied for 409B High Street, the permit in question in the instant appeal. To briefly recap the history, on or around July 30th, the appellant submitted an application for a residential short-term rental permit. On July 13th, the appellant was informed that the application could not be accessed because of an incorrect file format and was resent. On July 30th, the appellant received additional documentation from Metro to continue the permit application process and was issued the temporary residential permit, short-term rental permit, CASR number 2021-048520. In my brief, I failed to include the T in that, but again, the same concept follows. It was a temporary permit issued for 90 days with the understanding that the appellant and applicant would need to continue the permit application process, pay, and then be issued the final permit, as Mr. Hargis previously addressed. On August 2nd, the appellant began advertising the property with a temporary number displayed on the listings, errantly believing this would be within the confines of the laws that govern short-term rentals. Nonetheless, and unbeknownst to the appellant, said action was in violation of the STR laws and considered an advertisement of the property without proper permits. Thereafter, the appellant received a notice to correct violation on September 6th. That was dated October 31st, 2021. The appellant assumed that this was because of the fire marshal inspection not having been returned. Therefore, on September 10th, the appellant submitted said fire marshal inspection reports to Cindy Story, a office support representative senior for Metro, who then replied that the temporary permit was canceled. The appellant then spoke with Mr. McBroom and was informed of his misunderstanding of the 90-day temporary permits. Once put on notice, the appellant unlisted and ceased any advertisement of the property. And he does acknowledge that thereafter, the September 6th notice bookings were honored up into September 27th. On October 21st, counsel for the appellant filed the STRP application. Given that BL 2019-6 prevents any derivation or discretion by this board and the reduction of the penalty, it is likely that this is a futile motion. However, the appellant would assert that given the facts and circumstances surrounding this STR permit, that the zoning administrator erred in denying the permit and that the permit should be issued pursuant to the laws in which it was originally applied for. And at this time, I'd answer any questions from the board.
Any questions from the board members? Okay. Seeing none, we will hear from the opposition. If you'll again identify yourself.
Okay, I'm Heidi Carter, 1031 Antioch Pike, Nashville, Tennessee. We all know the case at hand. I don't know what you want me to say. So I get same concerns about the neighborhood and the 3 churches across the street, as well as the push for permit before the 4 houses next to it were completed is the timeline there too. So I feel like it was, the push is what's concerning for me. And yeah, the highly residential neighborhood. Thank you for your time.
Thank you so much. Any questions for the opposition? Mr. Klein, are you going to make use of your rebuttal time? You're going to cede that? All right.
I will cede my time back unless the board has any questions.
I have none. All right, we'll close the public hearing and begin deliberations. Don't see any reason to hold anyone in suspense.
I think it's the same thing.
Yep, same decision. So somebody will make a motion?
I'll make the motion to allow the appellant to file an application for an STR permit September 10th of 2022.
And is that upon a finding that the administrator did not err?
And that the administrator did not err, correct.
Okay. There's a second. All in favor? The vote appears unanimous.
Okay, Mr. Chairman, you adopt 5-0. Record show Ms. Kimberly departed.
Yes.
Participating. The one announcement, we held a case where the appellant did not show according to your rules. That case will be automatically deferred one meeting. That will be deferred to January the 26th, which is our next meeting. If such time the appellant does not show, it's Mr. Butler on Eastland Avenue. His case will be dismissed with prejudice. Finally, last item on your agenda is a amendment to your rules. I've sent to you all, your rules require any amendments thereto to be noticed to you members at least 10 days prior to this hearing. I made such notice to the board on November 23rd, 15 days for today, and requesting a change to your rules to amend this board's rules to the public notice portion of this to extend from 10 days to 21 days, requesting in doing so, one, to come into alignment with the Board of Zoning Appeals and its notice provision. So the upside is you provide additional notice to neighbors and adjoining property owners 3 weeks out rather than the current 10 days. But I will admit candidly, it does help our staff that we've got 3 weeks to prepare for this meeting, especially a large board meeting today. Mr. McBroom supports this change because he's the gentleman that puts together all this. 10 days, especially with holidays, it's 10 flat calendar days, so sure. It would help us out greatly. So that's what I put before this board. If you're inclined to do so, we'll need a motion. A second. Mr. Bond, as acting chair, I'll need you to sign this docket here. So
I'd make a motion that the rules be adopted as amended.
Second.
All right, there's a motion on the floor. All in favor? Aye.
Okay. Record reflects approved unanimously, and Mr. Chairman, it looks like we're adjourned.
All right.
Just for paper's sake, Bob Butler case, since we're not hearing it, can you save it back?
I was just going to hand. I'm going to hand back my entire stack.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.